Hello and welcome to the Data Privacy Lawyer. My name is Funmi Owolabi. Today's review is going to be on AI policy. So this one is actually a privacy notice. I've talked a lot in other reviews about the distinction between a notice and a policy. This one is actually a notice per the organization. It was last updated last year in October. So this one is actually called an AI privacy notice. There are different iterations that organizations are calling this document, but the value here is the fact that artificial intelligence does overlap with data protection, in that data protection touches every single business unit within an organization, including artificial intelligence in some capacity. And as such, there are responsibilities that are associated with how businesses use personal data in an AI capacity. So I'm just actually going to quickly hover over the products. They've got a couple of products here: Canvas, delivering dynamic learning experiences to every student. So the first thing that strikes out to me is the fact that we've got students involved. Now, specifically in the United States, there are certain factors that businesses must take into consideration if they are going to process the personal data related to a student. And there's specific thresholds from a federal perspective that need to be taken into account. So we've already identified one type of individual here. Now, I don't know the age of these students, but if the students are under the age of 13, we're also looking in the United States on a federal level at COPPA. And COPPA is a privacy legislation that dictates a specific manner in which the personal data of children can be processed. So that's the first thing. I've done many privacy reviews that look at a bit more detail into the products, but essentially what I wanted to talk about is I generally will get some overview of what a company is doing based on a review of their products, because that influences the applicable privacy laws. If you're not processing the personal data of children, then COPPA is not going to apply to you. But other privacy laws may. Let's say, for example, if you process the personal data of California residents, then you're looking at the CCPA. Let's say you're processing the personal data of a Maryland resident, we're looking at the MODPA. So knowing which privacy laws apply to you is really important, and I think companies need to be aware of that, particularly where we see that the focus group or the personal data that could be in scope here are related to students. So we're looking at things like FERPA, we might be looking at COPPA, and then we're also looking at the FTC Act Section 5, which talks about unfair or deceptive practices in the area of commerce, which we know it's the area of commerce because they're providing some type of product. All right, so we got K through 12, so we know immediately that children's personal data is going to be in scope. So we've got a couple of things we're looking at here. We're looking at federal privacy legislation. We're looking at state privacy legislation, particularly given the fact that it's likely we're going to have parents involved in this process too, right? Because we've got children's information. And then we're also looking at things like industry. The industry here is education. There are laws associated with education processing. And now we've also got the added component of artificial intelligence. So when we're looking at this from a business perspective, we're looking at lots of different factors that will influence what this notice is talking about. Now, a notice, generally, the audience for a notice are those who are consuming the products and services. A policy, generally, the audience for a policy are going to be internal stakeholders associated with the processing activities themselves. When I say internal stakeholders, I'm thinking about employees. I'm thinking about directors. I'm thinking about C-suite executives. Those are generally who a privacy policy is going to be addressing. A notice is going to be the consumers of these products, like the students, the parents. So I don't know everything about all of these products, but it's good to start throwing around ideas about what could be in scope for organizations that may be in a similar type of industry and want to know what might our obligations look like from a privacy perspective. So we've actually got additional notices. We've got one related to a product privacy notice. Now, we've got a product privacy notice, then we've got an artificial intelligence privacy notice. I think it's valuable for businesses to split their notices into the applicable group. It may be, now I don't know this for a fact, without looking at the technical specifications, I wouldn't be able to say one way or another, but it may be there are products that are available by this organization that don't have an artificial intelligence component to them. And what the demonstration here is, this notice is going to address processing associated with the artificial intelligence tools. The product privacy notices may be different. The practices associated with this organization may vary related to other products that don't have AI tools. So you're essentially putting your privacy practices into buckets. Now, I also want to give another example here of a notice that may be addressed to employees. We might have an employee privacy notice. That notice is going to address a company's practices associated with how they process employee data. This is for the product and this is for the AI tools. And they could be different. Let's say, for example, you have a specific repository associated with product-related processing activities. You might have one repository for that, and you may have a different repository for artificial intelligence. You may use the personal data associated with the AI tools different to how you use it for the product tools. And I also want to talk a little bit about tone and style. Now, although tone and style are not generally explicit in privacy legislation, the regulators that are creating the privacy laws are looking at whether or not businesses are addressing the audience. Who is the audience for the privacy documentation you're drafting? When we're looking at a privacy contract, like a data processing addendum, the data processing addendum, the audience there are privacy lawyers that negotiate and draft those DPAs. That's the audience. So the tone of a DPA is going to be very different to a product privacy notice for a student, because we already know that this is for K through 12. The audience for this tool is going to be different to the artificial intelligence privacy notice if the audience are enterprise businesses. Then we have something different. The tone, the language that's utilized is going to be very different. If your notice is written for your customers and your customers are students, but you're using language that addresses a privacy lawyer audience, then you're not really conveying the message that is required for the audience to understand what is happening with their personal data. You have to write it for the audience. I've talked about this in other reviews and you can check those out on my channel, but I have definitely identified certain provisions in notices where companies have drafted language that potentially only a privacy counsel will understand, using language such as controller without defining what a controller is, using language such as including different types of legislative pieces that customers won't be familiar with, or using different language that is specific to one geography without providing a definition. Those are valuable insights that the audience for a notice might want to know, which is why I think definitions are invaluable. This is quite a short AI notice. Let's look at sharing. As described above, our AI tools use language models and technology licensed from third parties. To operate our AI tools, we may share data you have entered into the AI tool with these third parties. In all cases, we require these service providers to keep your personal data secure, and we do not allow them to use or share data for any purpose other than providing services on the company's behalf. You may also learn more about our use of third parties in connection with the AI tools by reviewing these fact labels. I also think something that would be valuable is to list the service providers. In some geographies, this is actually a legal requirement. Now, without knowing the geographies in which these AI tools are offered, I wouldn't be able to opine on whether this information is missing, which is why geography is such an important piece of privacy. Let's say, for example, you are a US-based company. You only offer your services in the United States. You don't use any service providers outside the United States. You don't process personal data outside the United States. The laws that apply to you are going to be different to a company that is operated in the European Union, sells products in the United States, and has suppliers in China, because the personal data is all over the globe at that point. So that's also really important. And actually, one of the first questions I ever ask any client is, in which geography are the products and services offered? In which geographies do you process personal data? Those questions are very, very different. Where you offer your products and services may be different to where you process personal data. You could be obtaining data associated with your vendors and suppliers in, let's just say, Japan, but you sell your products and services exclusively in the United States. That doesn't mean that the only personal data you obtain is data in the US. You also obtain information on your vendors and suppliers who are located in Japan. There are laws that require you to process personal data in a specific manner in Japan that are different to the United States. So I really hope you enjoyed this particular review. If you have any comments or questions, leave a comment below and I'll see you in another one.